Now we consider the standard of care which is applied to individuals who've got professional credentials or other special skills. And that leads us to the case of Heath versus Swift Wings, and it also brings me back to Ms. Luton. And this is a tragic case for the people involved, but actually kind of interesting. Who is the plaintiff in this case? That's exactly right. And who are they suing? Correct? And, correct. What happened here? What did the pilot do wrong, allegedly? Right. Right. Mm-hmm. At the bottom of page 174, the witness testifies that the pilot didn't use flaps on the plane. Right. So the pilot made two different mistakes: not using the flaps at takeoff and not ditching the plane in a way that was designed to preserve life. Now at trial, what happened? Why? Right. Right. That's precisely right. So the appellate court's mad because they didn't think the trial judge got the negligence instruction right. Now, the bad language, not obscene words, but the improper legal language is right in the middle of the page. Here's the quote. With respect to aviation, negligence could be more specifically defined as the failure to exercise that degree of ordinary care and caution which an ordinary prudent pilot having the same training and experience as Fred Heath would have had. Now, if they just said which an ordinary prudent pilot would have used, that would have been okay, wouldn't it? Because that's an objective standard. This transition from objective to subjective is basically crossing the line from legal to illegal. And what makes the negligence instruction subjective is focusing on the defendant and whether or not that was reasonable, as opposed to the general reasonable man, as opposed to this one pilot. So Ms. Newton correctly says that this was an objective standard of care and that instead it should be a reasonably prudent pilot and nothing more than that. Now, suppose we've got somebody who is a professional, not necessarily a pilot, let's say a doctor or an attorney, who is a specialist. Look at the bottom of page 175, and the court points out that specialists are held to an even higher standard than other professions. So, in the law, I happen to know a number of legal practitioners who are certified estate planning specialists or certified family law specialists. And they take extra state bar classes. They get a credential from the state bar that says, Ms. So-and-so is a certified expert in family law. Okay, well, she is going to be held to the expert standard of care, whereas I, a licensed attorney who is not a family law specialist, would be held to a reasonable attorney standard. Yes. Yes, in California, there are official specialties that have actual state bar requirements. And there are a number. There's family law, there's corporate law, criminal law is one, estate planning is certainly one. There's a few others. So if you check off all those boxes and do what you're supposed to do, the state bar gives you a certificate, and you have additional continuing education requirements beyond that normal lawyers do too. And you get to hold yourself out as an expert, and you are more marketable in that respect in California, and you'll also be held to an expert standard of care, even above an ordinary profession. And the same is true in medicine. If you are a certified cardiologist specialist, as opposed to just some MD, you're going to be held to the specialist standard. And when you think about it, although like anywhere else in the law, there will be gray areas that will pinch, but basically this doesn't strike me as counterintuitive. Do you find it strange or not reasonable? Yeah. Like I said, a lot of this stuff, some of it's pretty complicated, but it's not completely counterintuitive. Now, I want to direct your attention to the last paragraph of this decision on page 176, because this is something that happens quite commonly, where a judge will assign blame for why we're hassling about this. This matter was well tried by both counsel for plaintiff and defendants. Several days were consumed in the trial. Nevertheless, because the judge is an idiot, get back and do this again. Now, he doesn't use that kind of bad language, judgmental language, but everybody knows that's what they're saying. Go to the notes and questions. Note 1. Now we see that there are more negligence actions involving people giving services. And basically, again, we're focusing on the objective standard. Look at page 177, a detail about litigation practice. The plaintiff has got to offer expert testimony to establish what the professional standard of care is in order to be able to persuasively make the point that the defendant failed to reach that standard. Note 5 tells you something you probably knew a long time before you enrolled in law school. Professional negligence, typically called malpractice. And then there are a number of different professions that are featured. Accountants, reasonable accountant standard. Architects and engineers, reasonable architect or engineer standard. Attorneys, reasonable attorney or reasonable specialist standard. But now, take a look at this section on clergy. Remember a few weeks ago we had that case about the rabbi who manipulated a parishioner into sex over trying to help her become more ready for marriage, or whatever his lame excuse was, and he was liable in intentional tort, but here he was not liable for clergy malpractice. And there's a whole bunch of cases involving priests there too. But notice what these cases all have in common is that the plaintiff is a grown-up. So there's plenty of Catholic clergy cases here, all involving consenting adults. This is different than the children cases. But in the children cases, those are not considered clergy malpractice. It's just considered child abuse or rape. Not the same thing as carelessness. Those cases, those priests, and sometimes their supervisors, are being found liable for intentional wrong, not liable for negligence. You see that pharmacists are held to a reasonable standard. Take a look at teachers. Is there such a thing as educational malpractice? Well, there may be such a thing as that, but it isn't a legally recognized doctrine. Note 7 at the bottom of 178 reinforces the idea that specialists are held to an even higher standard. Page 179, note 8. If you give services for free, you're still held to a professional standard. Price doesn't matter. Suppose you charge 4 times retail, well done. It does not equal a higher standard. It equals merely a higher profit. Next, we get to a kind of an interesting case called Hodges versus Carter. And that gets me to Mr. Sather. What was going on what did these lawyer defendants allegedly do wrong? Plaintiff brought
That's kind of two things. I believe that they were negligent in the process. Like, okay, so
Yeah.
so the plaintiff, I think, owned a store and it burned down. So he had 4 different was trying to get money out of it.
Right.
And so he sought counsel to get his money back. He needed a lawyer to help him do that.
So we got a plaintiff who's got a building and 4 fire insurance policies, and does he collect on any of these policies?
He can't because he's the lawyer.
So there's big hassles here about proof of service.
Yeah, first they said that the insurance commissioner could be served, but then someone else said he couldn't, and then the trial court. I think the trial court judge said that he could. Something there was a lot of confusion about that.
What was the bottom line as far as liability?
I think they found that the lawyers used their best judgment in their professional account.
Do you agree with that?
I don't know enough facts, but it seems like they gave the lawyers the account.
I very strongly felt that way. I looked at this case and I thought, well, in particular, let's see if I highlighted okay. Looking at the first full paragraph on page 180. Plaintiff alleges defendants were negligent in that they failed to do all this stuff, and then they had 60 days to actually serve them after they found out that there might be some hassles. And I looked at that and I said, well, how come that right there is not malpractice? And what the appellate court basically says is the lawyers acted reasonably, because this is similar to those cases about the standard practice in the industry, isn't it? Because these lawyers are saying, look, we always did it this way, and it always worked. And so our failure to do it this other proper way should be excused because it's the standard practice here. And the court basically says, right, no liability. And I looked at that and I said, well, wait a second. Why do you have lawyers? Really, why do you have lawyers to go after these guys? There were obviously service problems. Why not just connect the dots and do it properly within the time limit? And the lawyers get away with saying, because we didn't feel like it. We figured this was good enough. Now, in professional malpractice against lawyers, I've seen many cases involving trial. In trial, when a lawyer makes a tactical decision, like, for example, I'm not going to question this witness about issue X because I have a concern that idea Y is going to come out. Okay, so later on, the plaintiff's mad because they lost, and they sue the lawyer and say, okay, how come you didn't cross-examine that guy on this issue? And the lawyer says, well, I was worried that some other issue would come up. Okay, well, as long as the lawyer is able to articulate something vaguely reasonable, they get away with it, and they should. But I look at this one, and it seems like kind of a closer call. Look at the very last paragraph of this decision. Remember, a couple of decisions ago I said, hey, look, they're basically slamming the trial judge. Here, the appellate justices basically slam themselves. They say, okay, because of one thing we wrote in our earlier decision about how maybe the lawyers messed up, thus we have the instant litigation, and the appellate court basically said, we didn't intend to hold that, and we didn't hold that, so affirm. And then the first note, note 1, basically asked the same question I got through discussing with you a minute ago. Well, they had 60 more days. How is that not malpractice? And I love the bottom, the note 2 at the bottom of 181 and the top of 182. And all law students typically like this also, because you look into the future. Quote, professionals are not expected to know everything, just what the ordinary member of the profession does. See Lucas v. Ham, where a will and trust provision that violated the rule against perpetuities and the rule on restraint of alienation Of these topics, it was said, quote, few, if any, areas of the law have been more fraught with more confusion or concealed traps for the unwary draftsman. Attorney not liable. So what they're saying here basically is, in the law, there are some things so complicated and hard that a reasonable professional will not know them. I have a little bit of a degree of discomfort with that, but I also do not practice law in an area where the rule against perpetuities or restraints on alienation are prominent. Look at note 3. That goes into more detail about errors in judgment not being malpractice. Good example, Wood versus McGrath, 1999. Recommendation to settle without disclosing that the settlement agreement conceded issues that the client might have won. Not an exercise of best judgment. Look at note 7. A public defender has no immunity from a legal malpractice action. Now, those of you who are thinking about being public defenders one day, as I once was, should not be concerned about that, because everybody knows public defenders are comparatively poor, whereas the counties and cities they work for have highly deep pockets. So, public defender commits malpractice, city or county ends up being the principal defendant. Next we turn to the last big case that we have today, Boyce versus Brown. And that brings me once again to Mr. Walker. What was going on in this case? Mm-hmm. Yes. Right? And how long was it between the initial surgery and this patient being there? Do you think that's a reasonable length of time? Okay. What do you think what is the consequence of that lapse of time as to the strength of her claim against the first doctor? Does it strengthen or weaken the claim? Yeah, I wasn't clear on whether she had continual pain or whether she was basically okay and then got more pain. Do you know about that? I'm not clear on the facts myself on this point. I don't know. My impression was that she had the surgery and things were basically okay for a while, and then it started to hurt. Anybody got an answer on what the facts were on that? Let's have a quick look. Okay, so it looks to me as if from September 1927 to November 1934, basically she was okay, but she comes back and reports pain. So under those circumstances, I'd suggest those 7 years probably helps the doctor somewhat, particularly since there's a factual stipulation that at the time of the original surgery, the doctor conducted the surgery in a satisfactory way. We also know that the second surgery cures her completely, which I suggest makes the first doctor look not as good as he would otherwise, because you'd expect a full recovery. Now, take a look at the long paragraph starting close to the top of page 184. The court offers a 6-part rule for malpractice, and I offer this for your consideration not because I want you to memorize it, but because I want you to really understand it. Point one, the most common statement of the rule. A guy with a medical license or lady with a medical license is presumed to have the degree of skill that they say average member, I would say typical member of the medical profession has. Two, before a physician or surgeon can be held liable for malpractice, he must have done something below the reasonable standard. Three, affirmative evidence as to what reasonable professional care would be has to be shown by the plaintiff, presumably from expert testimony. Point four, negligence must always be proven, not based on presumptions, and that the negligent conduct also has to be proven by professional testimony, expert testimony. And finally, and interestingly, the testimony of other doctors that they would have done something different by itself doesn't establish liability for malpractice. Now, what about this issue of the X-ray? What do you have to say about that? Looking at the middle of page 185, quote, counsel for plaintiffs in argument apparently realized the weakness of their evidence on the vital point of what the medical standard was in 1934, and they based their claim of negligence almost entirely on the failure of defendant to take an X-ray of the ankle at the time, meaning at the later time. Because using an X-ray would have revealed the problem and it would have solved it. But the court finds that this evidence really isn't good enough, and the fact that the other doctor says he would have done it by itself doesn't prove the violation, and realize they are looking to find a violation at the time of the original surgery, and they don't find one, and thus the defendants win. Now, if we look at the notes and questions afterwards, we see in note 3, they reinforce the idea that expert testimony is required to establish malpractice unless it's obvious to everyone. So suppose we've got a situation where the plaintiff comes to the defendant and defendant's hospital with a badly injured right leg, and they end up amputating the left leg. Okay, well, we don't need Marcus Welby or some other famous TV doctor to come tell us what the standard of care is. We all know that's wrong. But in all of these other more technical cases, it's necessary to have expert witnesses. Look at note 5. We get back to this issue of customary practice. It actually matters quite a lot in medical cases, more in medical cases than elsewhere. But as the law has evolved over time, we see that the traditional deference to custom in the medical field is waning, meaning it's getting less. So again, we're focusing on what the person did and whether or not that is reasonable. And I'm pleased to report that for a change, we've actually completed all of the material that we're supposed to be covering this week. So now I can give you a great bar exam fact pattern without worrying that it will in any way compromise our keeping on time with everything in the class. Now this happens to be a recent California bar exam essay question from February of 2011. And I'm going to do the same thing I do each week. I'm going to pass this out in a moment. I'm going to give you about 15 or 20 minutes to take a look at it. It's a great question. Just about every issue that is presented in this question is one that we have looked at either tonight or last week. There are a few details that we're going to look at later, but I think you're going to find this to be a very constructive, useful question. So I will cease the recording now, distribute the question, then when it's time to come back, we will go through this question, and after that, we will all go out together into the hot night.